members of the community. So you can go listen to what he has to say and decide whether you want to call we agree or disagree or whatever you want to do. But he's asked us to announce it tonight, so it is announced. Second announcement. I want to remind the whole audience that the Committee 100 applications and the League of Women Voter applications are available in the back, so you can join up tonight and become a part of this process rather than just an observer. Okay, so I want to thank you all for coming. Bob Allen, let me tell you about who Bob Allen is. He's the mysterious Bob Allen. He's worked for 35 years as a telecommunications and technology attorney with a national practice, I do everywhere, representing companies from startups to Fortune 500. He's been listed in the multiple editions of the Martindale-Hubbell Bar Register of preeminent, not just normal, but preeminent U.S. lawyers. Bob served as an adjunct professor of communications at the American University Graduate School of Communication in Washington and as an assistant professor of communication at George Mason University in Northern Virginia. He's a former president of the Prince William and Manassas Family Alliance and the Prince William Committee of 100, of which we're somewhat familiar tonight. He was active in the Prince William Mass Transit Committee, an early advocate pressing for commuter rail in Northern Virginia, and a founder of Citizens for a Trans-County Parkway. I think some of you got here that way tonight. An organization that worked for the construction of what is today called the Kathleen Seafeld Parkway in the Mid-County area, where the speed limit is 75 miles an hour.
Clancy said it, okay? So, well, thanks, Clancy, for the introduction. I'm a former president of the Committee of 100, probably the formerest around in terms of longevity. Some of the rules I'd like to go over real quickly. I am to begin, I'm not going over all the rules, but the operative ones. I'm to begin by introducing the candidates, which I will do in a moment. The moderator is allowed to ask one question of the candidates. It's the same question for both candidates. Candidates are not to address questions directly to each other. There will be 2-minute opening statements, 2-minute closing statements. A coin toss determined the candidate who will make the first opening statement, and that's going to be Amy Ashworth. The loser of that coin toss, who was Mike May, had the choice of position in making the closing statement, so Mike has elected to make the last closing statement. The first candidate to respond to the first question will also be determined by coin toss, and Amy Ashworth came out on top on that coin toss. Candidates have 1 minute to respond to each question, 1 minute to each question. Rebuttal time, if needed, to clarify the record, will be 30 seconds. Timers will use a 30-second warning, a 15-second warning, and a stop sign. Stop. The audience is requested not to display partisan actions such as cheering, booing, hand clapping, or anything else. So now let me introduce the two candidates who are here tonight. Amy Ashworth is the Democratic. Prior to joining the office of the Commonwealth Attorney in 2005, Amy was in private practice in Manassas for 10 years, handling cases in the area of domestic relations, criminal defense and juvenile law, as well as acting as guardian ad litem for cases within the 31st Judicial Circuit. Amy received her JD degree from George Mason University School of Law in 1995 and a Bachelor of business administration degree from James Madison in 1992. She currently lives in Noakesville with her husband and 2 sons. Mike May. Michael C. Mike May is managing partner at May Law, LLP, a Northern Virginia firm of trial lawyers he founded with his wife, Amelia. An aggressive litigator, Mike represents clients in Prince William County and throughout Virginia in criminal, civil, and family law cases. He has 15 years of experience in courtroom litigation with hundreds of jury and bench trials under his belt. In fact, Mike has been recognized multiple times by his peers in the legal community as among the best attorneys in our Commonwealth. He was named among Virginia's legal elite 5 times since 2012. But most of you know Mike from his near decade of public service as an elected member of the Board of County Supervisors in Prince William County, where he represented the Occoquan District. In this capacity, he helped oversee the budget for Virginia's second largest county of almost 450,000 people. During his time in office, Mike worked to keep the county budget under control while still making key investments in police staffing and infrastructure to keep our families and neighborhoods safe. Mike is known as a tireless advocate for his constituents and their interests. He is very active as a volunteer board member for the Prince William Area Free Clinic, the community legal liaison for Nova Veterans Association. He's a member of the Knights of Columbus and the Prince William Bar Association. He also spent many years as an active member of the Lake Ridge Lions Club and as the Boys and Girls and on the Boys and Girls Club board. Mike has enjoyed volunteering as a moot court judge during law school competitions, sharing his expertise with the next generation of Virginia lawyers. A fluent Spanish speaker, Mike has also been honored to be a guest speaker on the issue of civil governance in coordination with non-government organizations in Mexico and Central America. And so those are our 2 panelists this evening. So is our timer ready? 2-minute opening statement, Ms. Ashworth.
Good evening, everyone. Thank you so much for coming out here tonight on a Wednesday night and giving us your time for these elections that are occurring on November 5th. Thank you to the League of Women Voters for hosting and for the Committee of 100 for hosting us this evening. As Bob said, I have been a lawyer here for 24 years. I have been both a defense attorney in the criminal justice system and a prosecutor in the criminal justice system. And the Commonwealth Attorney is the top prosecutor for Prince William County, Manassas, Manassas Park, and our 4 towns. I have taken the oath to be a prosecutor 7 times in my 24 years serving this community. First for Manassas Park, then for the town of Haymarket. Paul Ebert appointed me once as a special prosecutor in a case he had a conflict with. And then I joined the office as a full-time prosecutor where I was in the Special Victims Unit. I was in the courtroom every day for 11 years advocating for justice, because that is what a prosecutor does. It is not a political office, although we do run as a Democrat, myself, and a Republican, Mr. May. But in all my years of prosecuting, not once did politics come into any of the decision-making process that I went through for charging and handling those cases. My sole focus was keeping our community safe, our families safe, and making sure that justice was done in each and every case. Justice is a tricky concept. We all know it when we see it. Sometimes justice requires us to bring the full weight of the state down upon somebody and make sure they never walk the streets of our community again. And I have done that. And sometimes justice requires us to show mercy and compassion. Justice requires us to give somebody a break. I have lived here for 24 years. I have practiced law here for 24 years. My husband is a retired police lieutenant from the city of Manassas, and I have 2 teenage boys in our local school system. I would be honored to serve as your next Commonwealth Attorney, and I am here to earn your vote tonight, whether you're a Democrat or a Republican. Thank you.
Go ahead.
Good evening. My name is Mike May, and I'm running to be your next Commonwealth's Attorney. For the past 15 years, I've been a Virginia trial lawyer, currently the managing partner of my law firm known as May Law. I also served our community in elected office for 9 years on the Board of County Supervisors. 4 years ago, rather than run for re-election, I decided to run for the position of Commonwealth's Attorney. And a lot of people thought that was crazy. Going up against a longtime popular incumbent prosecutor in Paul Ebert was not an easy task. Plus, if I lost, well, I would lose a seat on the Board of County Supervisors. Well, that's what happened. And for me, it was never about politics. It was about a calling to serve our community in a new way. And I still feel that calling today, and that's why I'm running once again. Now, during my campaign 4 years ago, I was called just a politician. And it was also argued that I lacked experience, and I suspect you may hear some of those same themes tonight. So I will just tell you now, I'm not the former government prosecutor in this race, but that does not mean that I do not know the law. Instead, I chose to pursue my legal career in the private sector. I'm a Virginia trial attorney. People hire me to represent them in court and try cases on their behalf. And during my career, I've been involved in hundreds of cases, and I've represented clients in courts throughout Virginia. Some of those have been criminal cases, where I've gone up against seasoned prosecutors to protect the rights of the criminally accused. Some have been family law cases, where I fought for parents who were deprived of a relationship with their children. And some of them have been civil litigation cases, where I've protected victims of discrimination and assault. I'll put my courtroom litigation skills up against anybody, and I believe I have the legal experience to be the next Commonwealth's Attorney. But you have to remember that this job is not just about legal experience. If it were, it wouldn't be an elected position. This job requires the leadership and judgment to ensure justice for our community. And it also requires somebody who understands the policy side of the job. Things like the strategic plan, the budget, how to manage an office, and how to actively engage our community. I also had that experience. And that's the experience we need if we want to modernize this office and bring it into the 21st century. I thank you for your time this evening, and I look forward to your questions.
Thank you. First question, and the first question will be answered first by Ms. Ashworth. Should a Commonwealth attorney threaten to charge a defendant with a crime of a higher penalty in order to persuade that person to plead guilty to a crime with a lesser penalty? 1 minute.
As I said in my opening, the job of Commonwealth Attorney is to make sure that all of the assistants in the office and everybody working should, I think it's 1 minute if it helps, should pursue justice. Prosecutors should have to evaluate the facts of the case that come before them and look at the person's situation, look if they have a prior history, and decide what the right thing to do is in each individual case. And that's not an easy task sometimes. Prosecutors should never be in the business of withholding exculpatory information or information that the defense is entitled to have. They should never be in the business of threatening a person with higher charges in order to force a plea deal on somebody. Those actions are not seeking justice. And this system that you are electing a Commonwealth Attorney to is a criminal justice system. Thank you.
Thank you, Mr. May. The question again is, I can find it first. Should a Commonwealth Attorney threaten to charge a defendant with a crime of a higher penalty in order to persuade that person to plead guilty to a crime with a lesser penalty?
The purpose of the Commonwealth's Attorney's Office is to provide justice. If there is a basis for a criminal charge, then that charge can appropriately be brought. But I do not think it's appropriate for someone to threaten a higher charge for the purposes of securing a plea of a lower charge. I agree with Ms. Ashworth wholeheartedly that exculpatory evidence should not be withheld. And that's why when I ran for this office 4 years ago, I called for an open file discovery policy in that office. We still need to do that, and if I'm elected, we'll do that on day one.
Okay, the next question has to do with the opioid crisis. Some statistics show that opioid abuse now kills more people annually than traffic deaths. How can you, as Commonwealth's Attorney, best deal with this crisis? And further, part of the same question, is the prosecutor's role to address only the punitive aspects, or is there room for addressing treatment aspects? This goes to Mr. May.
I think there's certainly an opportunity for the Commonwealth's Attorney to be involved in the treatment aspect. One of the things that I would like to do as Commonwealth's Attorney is provide a lot more in the way of community outreach. When it comes to the opioid crisis, this is a multifaceted problem, and we're seeing various offices throughout the state approach this in different ways. There's matters on the civil side where people are going after the manufacturers. I think that economically that's a good way to go about it. I think at the end of the day, when we're talking about what's happening locally in Prince William County, we have to look at this as a disease, and we have to try to find appropriate treatment for the folks that are going through this crisis. There are a lot of interesting models in terms of diversion for drug issues, and I'm certainly open to those and working with the other folks in the office and the Community Services Board and other stakeholders to make sure that we're adequately addressing this problem. I think we also need to do a lot to reach out to our school community because certainly those kinds of problems begin with young people. We need to work with our schools. It's appropriate that we had a debate between our school board folks before this. It's really important.
Okay, and just to make sure, responses to the questions are 1-minute responses. If there is a rebuttal at all, it would be a 30-second. So now, Ms. Ashworth, same question, opioid crisis. Some statistics show that opioid abuse now kills more people annually than traffic deaths. How can you, as Commonwealth's Attorney, best deal with this crisis? And is the prosecutor's proper role to address only the punitive aspects, or is there room for addressing treatment aspects as well?
I cannot imagine anything worse than losing a loved one to drug addiction, and certainly to an overdose. As an elected official, the Commonwealth's Attorney certainly should be getting involved and doing whatever we can to prevent that from happening. We have to recognize as a nation that we have there is a population that has a problem with opioids. But I don't believe we can incarcerate our way out of this problem. I think we need to look at successful alternatives like drug courts to give people the incentive to stop using and to get treatment. And I believe we need to focus on increasing the mental health options. There's a reason why people are using drugs. They don't just wake up one day and say, I want to be a drug addict. So we need to get to the source of it.
Okay, next topic, prosecutorial discretion. And the first question here will go to Ms. Ashworth. Some of the most celebrated recent criminal cases have involved questions of prosecutorial discretion and possible abuse of this principle. For example, Jussie Smollett, Jeffrey Epstein. What do you consider to be the appropriate factors in exercising prosecutorial discretion? Is there a class, or are there classes of crimes under the Virginia Code that you would choose not to prosecute? If so, what are they and why?
Prosecutorial discretion is a very important part of the job of a prosecutor and as the Commonwealth Attorney. The Commonwealth Attorney oversees the assistants that work within that office. In Prince William County, we're up to about 28 assistants. And so you have to have a guiding principle for those assistants to understand the vision that you bring as the Commonwealth Attorney. On my website, I have put forth from day one my mission, which is working for justice for everyone and doing that in a fair and ethical manner. Now, as I said in my opening, you take an oath as the elected official and as all the assistants do to uphold the law. So I don't believe there is any class of cases where you can say, we're just not going to enforce those. Because that's the legislature's job, to make the law. The prosecutor's job is to enforce the law. But that's where that discretion comes in. That's where that opportunity to show mercy comes in, or to bring the hammer down when it's necessary.
Okay, Mr. May, some of the most celebrated recent criminal cases have involved questions of prosecutorial discretion and the possible abuse of this principle. The Smollett case, the Epstein matter. What do you consider to be the appropriate factors in exercising prosecutorial discretion? Is there a class, or are there classes of crimes under the code, under our Commonwealth Code, that you would choose not to prosecute? And if so, what are they?
And this has certainly been a hot topic in the area of criminal justice in Virginia of late, and we hear about it. I'm sure Ms. Ashworth hears about it on the campaign trail frequently. And I agree that ultimately the prosecutor takes an oath of office to enforce the law. Now, there are candidates running for Commonwealth's Attorney throughout Virginia who have essentially run on a platform of we're going to accomplish criminal justice reform by means of prosecutorial discretion. And I think that goes beyond what is envisioned by prosecutorial discretion. At the end of the day, you are electing a prosecutor, a Commonwealth's Attorney. You're not electing a queen or a king. You're not electing someone to make law by prosecutorial fiat. So we have a system in place. We need to put pressure on our legislature to enact the appropriate criminal laws and address disparities in the system, and then leave it up to our elected prosecutors to accurately and appropriately enforce the law. On a case-by-case basis, with mitigating circumstances, there's always the opportunity for discretion, but not as a general principle.
Okay, next topic, gun crimes. And this question goes to Mr. May first. Do we need additional legislation to prosecute crimes committed with guns? If so, what are they? Are we adequately enforcing existing laws addressing crimes committed with firearms?
The crimes committed with firearms are concerning to the entire community. We do, fortunately, have very appropriate laws in place to enhance penalties when you use a firearm in the commission of a felony. I absolutely support those laws, and if elected, I would expect all of our prosecutors to use those tools to try to deter folks from using firearms in violent episodes. I certainly think that mental health needs to be taken into account when it comes to firearm violence, but with respect to the actual criminal law, there are a lot of tools available to prosecutors right now. So I can assure you that if somebody commits a violent act with a firearm in Prince William County, Manassas, or Manassas Park, if I am prosecutor, we will prosecute it to the fullest extent possible.
Okay, now the same question to Ms. Ashworth. Do we need additional legislation to prosecute crimes committed with guns? If so, what are they? Are we adequately enforcing existing laws addressing crimes committed with firearms?
So the problem with the law that Mr. May is citing is that by the time the prosecutor gets the case, the crime with the gun has already been committed. And so saying things like, well, I'm going to prosecute them to the full extent of the law says, I don't quite understand the job, which means using prosecutorial discretion to figure out what the right thing is to do in a case. What's important is keeping the guns out of the hands of people who intend to do harm in the first place. I have said repeatedly that I want to focus our resources on domestic violence and the prevention of it. Many of the murders you see in Prince William County are from domestic violence. We have to be involved in day one on those cases.
Okay, next topic, death penalty. And this question goes to Ms. Ashworth first. Current Commonwealth's Attorney Paul Ebert has put more people on death row than any prosecutor in the state, mostly as a function of his tenure in office. What would your position be as Commonwealth's Attorney on application of the death penalty?
Thank you. So the death penalty is the law in the Commonwealth of Virginia. And if elected Commonwealth Attorney, as I said, I would take an oath to uphold that law. So in each case that comes before me, we will have to apply the law as it's written. I have said, and I say today, that I personally am opposed to the death penalty for many reasons. I have three main problems with it. One is that it is permanent. And if you've ever watched Netflix or HBO, you've seen that sometimes the criminal justice system doesn't get it right. And you can't undo the death penalty. Number two, it has historically been applied unfairly to people of color and poor people. And number three, it costs the taxpayers millions of dollars. That said, it is the law, and I would certainly uphold that.
Mr. May, current Commonwealth's Attorney Paul Ebert has put more people on death row than any prosecutor in Virginia, mostly as a function of his tenure in office. What would your position be as Commonwealth's Attorney on application of the death penalty?
The power to take your life away is the most awesome power that government can wield, and so I think it really needs to be used extremely sparingly. I don't think that when there's a death penalty case, it's something that we should celebrate. I don't think that the death penalty should be used as a means of revenge. But there are some crimes that are so heinous and so unspeakable that I believe that that needs to be reserved as an option to protect the safety of the community.
Do you have a rebuttal? 30 seconds.
Sadly, there isn't one study that shows that the death penalty does anything to deter crime. And so, that it's an illusion that it's going to keep our community safe.
You're still going to use it.
Okay, no chatting. Okay, so next topic, we're going to get into the area of white-collar crime. And this question is going to go first to Mr. May, I believe, who's on this round. What is the Commonwealth's Attorney's role in prosecuting white-collar crimes? For example, embezzlement, fraud, small local securities actions that may be committed in the county. Are current practices adequate? If not, what do you intend to do to change the Commonwealth Attorney's response with respect to white-collar crime?
Prince William County has been changing a lot, and I think as we have grown and changed, there probably will be more of a role to play in the area of white-collar crime. The issue that we've had, over the past 50 years is that we've primarily been a bedroom community, where most of the business activity takes place outside the jurisdiction. People essentially live here, but they're working outside the jurisdiction. And so there isn't a huge business base where you might expect a great deal of white-collar crime to occur. But certainly when white-collar crime occurs within the community, the Commonwealth's attorney's role is to prosecute as it would be in any other case. So I'm certainly open to looking at, particularly as the business base grows. I think that there will be more opportunities to consider what's happening out there in the community and opportunities to bring prosecution, but obviously it hasn't been a priority of the existing Commonwealth's attorney. I think that's just been a function of the nature of Prince William County and how it's grown and changed over time.
Okay, Ms. Ashworth, what is the Commonwealth's attorney's role in prosecuting white-collar crimes such as embezzlement, fraud, small local securities actions committed in the county? Are current practices adequate? If not, what do you intend to do to change the Commonwealth's attorney's response to white-collar crime?
Thank you. So if you talk to any business owners in the community, you would know that white-collar crime is very prevalent in this jurisdiction. When I was prosecutor for both Manassas Park and the town of Haymarket and in the Commonwealth Attorney's Office, we had many cases of white-collar crime. It's not exciting. It doesn't generate a lot of media attention or excitement within the office. I think we even had a case once where a prosecutor had a juror fall asleep during a white-collar crime. These things happen. But your role as Commonwealth Attorney is to prosecute crime that occurs in the county. The current office has been doing it, and I would make sure that we continue to do that. Whenever somebody breaks the law, the Commonwealth Attorney is there to make sure justice is done. What I would like to see is more of a focus on restitution and making sure that the money gets paid back from the people that have been, the business owners that have been stolen from, without necessarily incarcerating people for long periods of time for a nonviolent offense.
Mr. May, are you looking for a rebuttal?
Just
30 seconds.
I certainly did not mean to imply that there is no white-collar crime. I think I was just commenting on as compared to a lot of other jurisdictions with much more business activity. There's probably less here, but certainly prosecuting white-collar crime when it occurs here needs to continue.
Okay, so let me see. Next question. Race relations and hate crimes is the topic. And this goes to Ms. Ashworth first. What is the Commonwealth Attorney's role in prosecuting hate crimes committed in the county? Are current practices adequate? If not, what do you intend to do to change the Commonwealth's Attorney's response?
So the Commonwealth Attorney's role, once again, is to prosecute the crimes that are brought. As far as hate crimes go, there's an additional element of an offense. So it would be like an assault and battery charge where you have the elements, and then the additional charge is that it was done.
Assailant, and that can be a challenging thing to do from an evidentiary standpoint. Having said that, I think that the Commonwealth's Attorney's Office needs to have the courage to bring those cases forward, even if you're going to lose, because you will send a message to the community.
I need all the help I can get. We'll give it to Mr. May first, okay? A ruling from the table. Okay, that's fine. First question to Mr. May. What is your position with regard to cooperation of local officials with federal authorities in the enforcement of federal immigration laws? Should Prince William County continue its participation in the 287G program? Should it become a sanctuary jurisdiction? Are there factors in mitigation that the Commonwealth's attorney should consider in cooperation with federal authorities?
Well, as many may know, the community entered into the 287G agreement when I was a member of the Board of County Supervisors in 2008. And this was a partnership with the Obama administration, and it was entered into by the jail board, and this program has continued at the jail since 2008, all through the Obama administration. They work together. Now into the new Trump administration, they continue to work together. I think the program makes sense. Essentially what it says is, if you commit a crime in the community and you go to the jail for screening, you'll be checked for immigration, and if immigration is interested in you, then they will take the appropriate steps to pick you up. Ultimately, this is about making sure that folks that commit crimes in the community are not returned back into the community when they can be sent to another place. I think it makes sense. I think Sheriff Hill said it best. This is a matter of not just homeland security, but hometown security. I do think there's more that the Commonwealth's attorney can do, however, in terms of outreach to communities, particularly immigrant communities, to make sure that they understand that they have no fear to talk to and cooperate with the police department.
Okay.
We've been doing that.
Okay, so now to Ms. Ashworth. What is your position with regard to cooperation of local officials with federal authorities in the enforcement of federal immigration laws? Should Prince William County continue its participation in the 287G program? Should it become a sanctuary jurisdiction? Are there factors in mitigation that the Commonwealth's attorney should consider in cooperation with federal authorities?
So I was a prosecutor here in Prince William County when the 287G program that Mr. May voted in favor of went into place. And the impact on our community being safe was negative. We created an entire class of people, namely immigrants, some legal, some not legal, but they were afraid to come forward and report crimes. And I knew this because they found their way into my office in the Special Victims Unit through a family friend, through a lawyer, saying, my child's been sexually abused, but I'm afraid if we report this to the police, they're gonna deport me. This is a program that has cost the taxpayers over $2.5 million, and it does nothing to ensure your safety. What it does is, as you said, screens people so they, if they are illegal, can be deported, but many times they would be deported or taken into federal custody before they ever saw the courtroom for their day of justice.
Okay, is there a rebuttal, 30 seconds?
This has been going on since 2008. I know Ms. Ashworth's been active in the community. We never heard from her that this was a concern when it was passed, and that was many, many years ago. We're now talking about it now because folks want to nationalize the local elections and turn this into a national issue, when in fact this is something we've been doing successfully. And I want to give credit to Chief Dean, and I want to give credit to his follow-up police chiefs. They've done so much outreach in the community, so much outreach in the Latino community to explain to them what this program is, what this program is not, so they understand that they're safe and they can cooperate with law enforcement. That's why crime rates are going down.
Okay, thank you. Next topic, sex crimes. And this is going to, we're going to start with Ms. Ashworth first. The Pennsylvania Attorney General recently released a scathing report on sex abuse perpetrated by some Catholic priests over a period of decades. What is the Commonwealth's attorney's role in investigating and responding to such systemic abuse by trusted members of the community, including teachers, religious officials, etc.? Are current practices adequate? And if not, what do you intend to do to change the Commonwealth Attorney's response?
Well, I am happy to tell you that when I became part of the Special Victims Unit in Prince William County, we made a lot of changes to improve the service of justice in those cases. We worked hand in hand with victim witness in ways that had not been done before to make sure that victims felt safe coming forward. You have to remember with special victims, often your victim is a child who has to sit in a courtroom 4 feet in front of their offender and tell a complete room of strangers, the jury, what happened to them. Those are very difficult cases. And I'm proud of the work that my colleagues still do there in the Special Victims Unit. And that is one of the most important areas of law that a Commonwealth Attorney handles and makes sure gets proper justice. And so I would continue to encourage the training and focus of those very good, experienced prosecutors to handle those cases and continue to work hand in hand with the victim witness section of the office to make sure that continues.
Okay, Mr. May, the Pennsylvania Attorney General recently released a scathing report on sex abuse perpetrated by some Catholic priests over decades. What is the Commonwealth's attorney's role in investigating and responding to such systemic abuse by trusted members of the community, including teachers, religious officials, etc.? Are current practices adequate? If not, what do you intend to do to change the Commonwealth's attorney's response?
Well, I also want to commend the folks that work in that particular line of work. It's probably one of the worst kind of things that you can imagine. And when I read that report, I was sickened by it. And so the role of the Commonwealth's attorney in Virginia is to investigate and prosecute those crimes appropriately. And I certainly will, if elected, give all my support to the folks on the ground that are dealing with those issues to make sure that they continue to be prosecuted.
Okay, next question. You'll be happy to know that there are 2 more questions. That's all, only 2 more. This is for Mr. May. How do you feel about eliminating recommendation for cash bail for low-level offenses? Do you feel this is a discriminatory practice? Mr. May first.
Well, I think the prosecutor's office needs to be focused on whether the accused is a danger to the community and a flight risk. And cash bail is certainly something that's been talked about significantly. And as a matter of fundamental fairness, we don't want someone to stay in jail longer than their likely sentence because they can't pay the bond. When I was on the Board of County Supervisors, we had to fund the expansion of the jail. And we want to make sure that those additional beds are used in a manner to keep the community safe, not to keep people locked up while they're awaiting trial. The issue I have, and there's been a movement throughout the Commonwealth as part of these criminal justice reform moves to eliminate cash bail, is I think it's going to take a partnership. Bail is set by the judges, of course, but a prosecutor has a lot of influence in what he or she may request. But the bigger issue for me is if you're going to eliminate cash bail, and again, I really wouldn't pursue it in the majority of cases, but I wouldn't eliminate it outright. I think that we need the legislature to get involved here and put more money, and the Board of Supervisors, more money into pretrial services, because ultimately you do need someone to make sure that those folks
Thank you,
Sorry.
Mr. May. Okay, now, same question to Ms. Ashworth. How do you feel about eliminating recommendation for cash bail for low-level offenses? Do you feel this is a discriminatory practice?
So when somebody gets arrested by the police, they are brought in front of the magistrate, which is at the detention center. And the magistrate is the one that sets the bail. The magistrate makes sure that there's probable cause, that the arrest was made properly, and sets a bail or bond. In other words, they say, if you post $2,000 or $5,000 or $10,000, you can go home. If you can't afford to post that bail or pay a bondsman to do it or get one of your friends or family members to do it, you stay in jail. And you stay in jail until your court date. Now, if you're a violent offender, you probably shouldn't have a bail. You should wait in jail because we don't want you to hurt anybody until your next trial date. Or if you're at risk of leaving the jurisdiction, then you should not be given a bail. But many times, this is discriminatory against poor people who can't afford it. So they wait in jail, presumed to be innocent, until their trial date.
Okay. Thank you. Okay, now the last question will go to Ms. Ashworth first. While the Commonwealth's attorney is essentially a prosecutor, do you think the staff should include a witness victim advocate? What role would such a person play? If you do think that such a role is appropriate.
Yes, I have mentioned this also throughout this evening. The Commonwealth Attorney's Office does have a victim witness office. They have people that are assigned to the case. They meet with the victim. They make sure that the victim knows what's happening in the case. They can get in touch with the prosecutor. They can explain what's happening. They can even sit with them in the courtroom as that added comfort person. This has been a fabulous program that we have had for years. I absolutely think it should continue, and I think it should be utilized even more so in many of the other cases that not just special victims and violent crimes. So I am definitely an advocate for keeping this program and carrying it forward.
Okay, Mr. May, while the Commonwealth's attorney is essentially a prosecutor, do you think the staff should include a witness victim advocate? What role would this person play?
Yes, I do think that the victim witness advocate plays an important role and should remain. In fact, if I'm not mistaken, this program was started by Mr. Ebert, and to his credit, he's continued to support it and maintain it for a number of years. These folks help people during some of the most difficult times in their lives, and a lot of times the assistant Commonwealth's attorneys are preparing for a case. They're kind of focused on the evidence, they're focused on the things they need to do, and the victim witness advocate can really help shield the person through a very, very difficult time. As Ashworth talked about, certain kinds of victims, children and the like. This person is invaluable in the system, and I would continue to support having those folks in the office.
Okay, I guess that finishes the questions. Now, we earlier drew lots or did a coin toss that resulted in the decision that Ms. Ashworth is going to do her closing statement first, 2 minutes, and to be followed by Mr. May, also 2 minutes. So proceed when you're ready.
Thank you. So I left the Commonwealth Attorney's Office 3 years ago, not really ever intending to run for this office. I'd gotten a job as the managing partner at a local law firm, Farrell & Croft. I was living my very happy life as a lawyer in private practice. I am here today because I am passionate about bringing criminal justice and keeping our families safe here in Prince William County. The person you elect as your next Commonwealth Attorney will take office on January 1, 2020. When I checked the court files last week, there were 6 murder trials scheduled in January of 2020. I can try any one of those cases because I have been there and I have done that. I have tried those cases, rape cases, murder cases, burglary, speeding tickets, you name it. I have the experience to handle those cases, and we are too big of a jurisdiction to leave this to somebody that doesn't have any experience as a prosecutor. I intend to transform this office to make it more efficient and more responsive to all of the actors within the criminal justice system. Open file discovery should be a policy that we enact immediately. It makes it easier on everybody. The police should have a responsive Commonwealth Attorney's Office that doesn't make them wait to have their questions answered. Our victims should be treated with respect and dignity, and the defendants should be given, rights need to be respected, and they should be given a fair trial. After all, our Pledge of Allegiance says justice for all. The choice for the voters is an experienced prosecutor versus a politician. Experience matters. Thank you.
Go ahead.
So you've heard a lot about experience, and Ms. Ashworth, my opponent, did work in the office for 11 years. And for 11 years, she had the opportunity to seek change, but she really didn't do anything. She had the opportunity to set an example for reform, but she didn't do anything. She was perfectly content with the good old boy system that exists there today. In fact, 4 years ago, when I spoke of the need for transparency, discovery reform, open hiring, a more diverse workforce, budget reform, and community outreach, my opponent actively supported the status quo. And now that the status quo no longer serves her purposes, she purports to be a crusader for reform. She calls me a politician, but everything I've said to you tonight and everything I will say to you is exactly what I said to you 4 years ago. Ms. Ashworth, on the other hand, is telling you what she thinks you want to hear and singing a different tune than she sang 4 years ago when she sat in the front row of these debates wearing my opponent's t-shirt. Now, if you want a good old boy who's going to be backslapping the criminal defense attorneys in the hallways and cutting lazy plea deals without input from our police officers, I'm not your guy. If you want an insider, I'm not your guy. But if you want someone who will remember that the position of Commonwealth's attorney belongs to you, I ask for your vote. It's time for new leadership. Our community has changed a great deal in the past 50 years. 50 years ago, this was a part-time position with one assistant. Today, we have over 25 assistants and a similar number of support staff and a budget of over $6 million. There are approximately 6,000 felony matters and another 80,000 misdemeanors a year. The most important function of this office remains keeping the community safe, but we must modernize this office if we're going to continue to do so effectively. We have to modernize our discovery practices, our hiring practices, our compensation system, and we have to modernize the manner in which this office interacts with the community, local government partners, and stakeholders in the criminal justice system. I know how to do this. My background as a trial lawyer and elected leader put me in a unique position to do so, and with your help and support, we will. Thank you.
So let's give our office seekers a round of applause. Nancy, do you have any closing comments or remarks?